on the regulations for cryptocurrencies. Uh, Before we begin, I'd like to just explain a little bit about what this is. Cryptocurrencies, as many of you would know, it's quite of a booming market as of recent. It involves coins like the Bitcoin, Litecoin, Ethereum, and stuff. So then I will just be going on about the brief explanation and overview as to what the regulations are for that has been enforced in Malaysia onto these digital assets. Now again, for those who are new here, I would like to just clarify that all our presentations that has been conducted by all of us within Thomas Phillip is simply for educational purposes, and that this is not to be taken as a legal advice provided by us in any way whatsoever. Now, this is the outline of today's talk. So first, we'll just talk about what is cryptocurrency again and how it's been recognized within Malaysia and as well in other foreign jurisdictions. I will then move on to explain about the types of laws and the regulations that have been implemented to regulate cryptocurrency within Malaysia. And then I'll finish off with how other laws, such as the Anti-Money Laundering Act and maybe some of the tax-related laws, will apply to these digital assets. Now, before I go on to the body, I'd just like to do a very quick sound check. I hope that everybody is able to hear me loud and clear. Just maybe give me a yes or no, whether you can hear properly in the chat box for those who are attending the Zoom talk. Am I loud and clear? All right. Okay, thanks everybody. All right, okay. Let me know if there may be some technical issues midway, and I will just see how we can stop by. Okay, so moving on. What is cryptocurrency? As I just mentioned, cryptocurrency, or also known as crypto in most short form kind of thing. These are coins which are used as a digital currency or is a digital asset that can be exchanged for goods and services and can even be traded online without any border restrictions. Now, these coins are usually stored in a thing called a ledger, which is usually like a thumb drive kind of thing, that exists in the form of a computerized database and utilizes strong cryptography to secure transaction records, control the creation of additional coins, as well as to verify the transfer of coin ownership. As such, it is clear that these coins do not actually exist in any physical form, such as, our paper money. Now, however, for one to access these coins, you have to exchange the real currency. So you have to use real money to obtain this cryptocurrency. So think of it as maybe going to a casino and you're exchanging money for tokens or the chips that you use to play your games in there. So although there are maybe lots of different cryptocurrencies currently out there, some of the very, very popular examples would, of course, be Bitcoin, Ethereum, XRP, Litecoin, and even Tether. There are so much more. And, well, these are some of the very more popular ones out there. So what exactly is this decentralized control of cryptocurrency? Okay, the reason why this has been so booming as of recent is because cryptocurrency uses a technology called blockchain. Blockchain is basically what you call a decentralized technology that spreads across many computers that manages and records the transactions. This is very attractive to some because to those that are processing and recording the systems, as it may be found to be more secure than some of the traditional payment systems that are being used. Decentralized control is also very different to centralized digital currency and the central banking systems. Centralized here means that where a currency is minted or created, then prior to the issuance to a single issuer, then it would be considered centralized. So in other words, like what our banks are doing. So as such, there are some that enjoy the fact that cryptocurrency, being a decentralized system, has removed banks from managing the money supply, as banks have tend to, reduce the value of money due to economy inflation, as you would have seen in previous some of the biggest inflations in the past, in the histories. So there has been so when there's a decentralized system that's involved as well, a series of computers would be involved, unlike that of a centralized system. So in this case, when there is more computers involved, it allows one to have what you call an anonymity in the transactions, and it will be less prone to server hacks or a server downtime. So I provided here in this slide a very good diagram as to the differences between centralized and decentralized. Now moving on, this is a very interesting diagram that was provided by Blockgeeks. Now, they explain here as to how transactions involve cryptocurrency are being carried out and how it being decentralized and a decentralized assets would have a lack of physical form, and show how that comes into the whole transaction here. So I won't go so much into details, but this is maybe for those who want the presentation slides later on, and you can maybe look into it and see how transactions are being carried out with cryptocurrency. Now, moving on to how cryptocurrency is being recognized. Now, the question is, one being that, is cryptocurrency recognized as money in Malaysia? Now, Bank Negara Malaysia has officially declared that cryptocurrency is not recognized as money or as a legal tender in Malaysia, as provided under Section 20 of the Central Bank of Malaysia Act 1958. The bank is the only one that has the power to declare whether a token is able to pass as a legal tender. And in this case, they have clearly declared that cryptocurrency would not be recognized as money. So with this, does that mean that cryptocurrency is actually deemed to be illegal in Malaysia? Now, the answer to that is no. It is because the Securities Commission of Malaysia, a body that regulates the issuance of digital assets, which includes digital currencies and digital tokens via initial coin offerings known as ICO, and the trading of digital assets at digital asset exchanges in Malaysia would be the body that regulates all this instead of Bank Negara Malaysia. There is no doubt that Malaysia has not completely banned the use of these whole assets, and it's quite clear that regulations are being put into place, being discussed as as this whole digital assets is getting more and more popular as things as time goes by. And this is so to ensure that with all these regulations in place, they're hoping that maybe it will promote fair and orderly trading to ensure that investors are also protected. So there are things with the ICO issuers and digital asset exchanges, which are then involved in the issuance or billing of digital assets, with a payment function that will, however, need to comply with relevant Bank Negara Malaysia laws. So even if Securities Commission is the one that regulates the issuance, when there are certain exchanges, like remember I was mentioning earlier that cryptocurrency, you still have to use real money to exchange that. And when you do that transactions, then you will have to comply with the relevant Bank Negara Malaysia laws accordingly. Now, in addition to that, the ICO issuers and digital asset exchanges would also then be subjected to the Security Commission's guidelines on the prevention of money laundering and terrorism financing. As I mentioned earlier, we will deal with that at the end of this presentation, where we briefly discuss about how these digital assets come into the whole anti-money laundering law kind of thing. So I believe it is quite clear there's a picture that we can paint where even though cryptocurrency is not a money or a legal tender, it's quite clear that there seems to be an involvement of both bodies, the Bank Negara Malaysia, as well as the Security Commissions in regulating this whole digital assets, but of course at different levels of the transactions. Now I'll move on to a very interesting session courts case. This was the very first case in Malaysia, known as Luno Pte Limited and Robert Ong Tian Cheng 2021 LNS 2194. So this was the very first case in Malaysia that involved the trading of digital currency. So a little bit of a interesting background of the facts was that the first plaintiff was known as Luno, and it was a Singapore company that conducts its business as an online wallet and exchange of digital currencies. And then the second plaintiff in this case was known as Bits Malaysia. There was a company that is wholly owned by Luno and acts as an intermediary, regional operating center of Luno, and holds a bank account that accepts deposits from Luno's customers in Malaysia. Now, the defendant in this case was known as Robert Ong, who is an individual and is a registered user of Luno. Now, what happened in this case was Robert Ong was a holder of about 11.3 Bitcoins in his Luno wallet. He then transferred, he requested that these 11.3 Bitcoins be withdrawn from his wallet into a third party named, their name Bitfinex. They are the ones where they have an e-wallet account that was managed and operated by them. And they did not have any relations to both Luno or Bits Malaysia. So what happened was Luno accepted that request to transfer that 11.3 to Bitfinex. But then what happened then was after doing that, they then mistakenly transferred an additional 11.3 Bitcoins back into Robert Ong's account. So upon doing that, one of the representatives of Luno then told Robert Ong, hey, what we did was actually a mistake. Maybe could you then retransfer back 11.3 Bitcoins to us? Robert Ong then said, no, why not I transfer you in 300,000 in ringgit, which is equivalent to that 11.3 Bitcoins. Now, unfortunately, with how Bitcoin's value has always been fluctuating day by day, and you know how volatile that coin's value is, Luno then said, no, they want it in Bitcoin. So despite having that up and down, back and forth correspondences between Luno and Robert Ong, they couldn't come to an agreement. And eventually Robert Ong just chose not to transfer back that Bitcoin back to Luno. So then Luno then filed this suit against Robert Ong. And they basically said that Robert Ong owed them this 11.3 and that they want to claim this 11.3 through this suit from Robert Ong. Now, one of the very interesting points that Robert Ong raised in his defense here was that he raised that cryptocurrency was illegal in Malaysia and as such was not entitled to recover the same and should thus be recompensated in cash instead. So he was saying that, okay, Bitcoin is illegal. We shouldn't be having that transactions anyway. He's saying that instead of I transfer that Bitcoin, why not I do it in the 300,000? So the Sessions Court judge, his name of Zulkarnain bin Hassan, then held that Robert Ong's allegation here is fallacious, as while cryptocurrency is not recognized as a legal tender in Malaysia, this does not actually mean that Luno's operation is fully illegal. In fact, Luno is registered as a reporting entity with Bank Negara Malaysia, and that this is supported by contemporaneous documents. So it was stated here that cryptocurrency is actually not illegal per se, even though it's not recognized as a legal tender. Now, what happened then on was the Session Court went through a lengthy discussion to discuss about how digital currencies were not recognized as a legal tender. However, it again makes emphasis that although it's not as it is not completely illegal, the laws in Malaysia would then apply in this case. So as there was a contract between, I believe, because Robert Ong was a user of Luno's wallet, there was some sort of agreed kind of terms. The court then held that Section 73 of the Contracts Act pertaining to unjust enrichment was applicable in this case because Robert Ong was unjustly enriched when he received back the 11.3 bitcoins from Luno. But again, after much discussions, the Sessions Court again went to say even though cryptocurrency was not completely illegal per se, the operations that were being carried out by Luno at that time was considered to be illegal and thus could not be protected for restitution. So it was a very weird kind of line that they took on this case. Now, the High Court then eventually went on to state the very same. They went to support the Session Court's decision. As you know, the Session Court, even though they went on to say that okay, the coin was not illegal, but then for some reason the operations that were being carried out by Luno was actually illegal at that time because there was still no regulations, no laws on the security commissions, which I will eventually go on to explain later how the security commissions have come up with these guidelines to make you a proper digital asset exchange person, to which Luno did not adhere to at that time of this court. And that's why they deemed the operations being run by Luno illegal. So then, even all that, the Sessions Court still said that Robert Ong was still required to transfer the 11.3 bitcoins back to Luno. So him being unsatisfied, he appealed to that and he went to the High Court. He then raised, in respect of bitcoins, that he was trying to say that it should not, the Section 73 on unjust of the Contracts Act on unjust enrichment should not be applicable. And as such, the 11.3 bitcoins cannot be transferred as envisaged under this section. Now, in respect of this, Luno and BIX argued that although cryptocurrency was again not a money or a legal tender, it has been defined to be a form of security under Section 3 of the Capital Markets and Services Prescription of Securities, Digital Currency, and Digital Token Order 2019, to which I will further elaborate later in the presentation. And then what they then said that even though cryptocurrencies are not a form of commodity, there is indeed a value that's attached to the Bitcoin in the same way as value is being attached to shares. So as such, Bitcoin ought to fall under application of Section 73 of the Contracts Act. Now, what then happened was, again, the High Court then agreed to this, but then in respect to the claim of restitution, the High Court again agreed with the Sessions Court that because Luno and BIX operations were deemed illegal at that time and is thus contrary to public policy, the claim of restitution then cannot be sustained. So now this case was a very interesting case that went on to talk about the legality of the cryptocurrency, but also the legality of the business that were being involved with cryptocurrency. Now, I will go on further in this webinar. We will further see how his decision and why that decision has come as it is. Before that, I will just briefly go through this a little bit on the legality of cryptocurrency in foreign jurisdictions. We're currently on the jurisdiction of Malaysia, but let's see, there's other jurisdictions such as Singapore, Germany, Malta, Holland, Japan, USA, France, Canada, Belarus, Vietnam, and India. So in this country, when I mean by legalized here, it also means that what they have done is they have recognized digital currencies as a legal tender, unlike in Malaysia. So in these countries, I'm not exactly sure to what extent, because there's a lot of ongoing discussions as to how this trade take place in all these jurisdictions. So what they do is they have allowed for payments to be made through the exchange of digital currencies, and there has been digital currency that's being used for trading purposes. Now that is different to Malaysia, where however we don't see like, let's say that I go and buy a product, I will have your services for maybe 11.3 Bitcoin, then we sign an agreement, that kind of trade that's going on. So what happened then is most countries have started to take on the same position as what Malaysia has done, in where they don't actually legalize it, but they don't actually make it completely illegal as well. So these countries are like South Africa, Costa Rica, China, Japan, Hong Kong, South Korea, the UK, and Taiwan. Now, just note one thing though, that although I provide like a list here, this is actually not the full list of the countries that have been involved with whether it's legalized or whether cryptocurrency is legal. This is just a few examples I'm providing here. Now, however, unlike some countries, they have completely taken to make cryptocurrencies fully illegal, in where they don't even make cryptocurrencies. They don't allow the trading of cryptocurrencies. They don't even have regulations to it. They completely deem it to be banned, and they just don't allow the application of it completely. So in these countries would be Algeria, Bolivia, Ecuador, Bangladesh, Nepal, and Macedonia. For the countries that have taken the illegal route, it is actually just this few as of now, as of to date. I'm not sure if there's more, but yeah, for the countries that are illegal, these are the very few, because like I said, I think this is such a very new concept and things. Most countries, they don't want to really go into the whole, oh yeah, it's illegal kind of thing immediately. So they want to have a bit of a leeway and see how regulations can still be enforced. I've seen one quick question here. Where does China stand in terms of the crypto jurisdiction? As I mentioned, I believe at first I understand there was a huge ban about it. They completely illegalized it, and they made a huge ban. The same went for South Korea as well. But I believe that there are ways to go about it. Like I understand in China, some parts of it, I'm not sure if parts of the whole of China, what they do is the banks have banned it. So some people have learned to bypass that. But even if you bypass it, I believe it's not completely an illegal way per se, because I think they were having a bit of an issue regulating it. So what they did was they then made it legal to a certain extent, but not completely illegal, where they did the full ban as like, Algeria, Bolivia, because it's been kind of crazy. So it's very hard to control market. So China has currently, I believe it would stand under legal. They deem it to be legal, but as to what regulations and stuff, I'm not too familiar exactly. Yeah. So the enforcement of the CMSA amendment. So I referred to, just now in the High Court suit of Luno, where they then referred to a certain order. This is the order that was enforced in Malaysia in about January 15, 2019. It was one of the biggest amendments that was made to the Capital Markets and Services Act. And this was made specifically for to reflect the changes for the digital currencies platform. So with this amendment, it basically states that all platform operators would be required to apply to the Securities Commission for authorization. Now, the Securities Commission will then have that duty to evaluate all the applications and then only authorize the market operators that fulfill the relevant requirements. So remember how I was saying previously in Luno, at that time when that court case came in, they were making a big deal about Luno being an illegal transaction and stuff. That was because they did not, at that time, there was no guidelines that were being involved in it. That's why they're actually not a proper known body to the Security Commissions Act. The Security Commissions. So that's why there was that thin line where they were saying that, because of this, they cannot be actually recognized per se. So moving on. So the CMSA amendments, I'll go through this quite briefly as to what this order has brought and how it has affected. As you can see, one of the amendments that are made here was the implementation of what digital currency means. So it basically means in section 2, sorry, they added this in section 2. Digital currency is a digital representation of value which is recorded on a distributed digital ledger, whether cryptographically secured or otherwise, that functions as a medium of exchange and is interchangeable with any money, including through the crediting or debiting of an account. In other words, cryptocurrency. As you know, I was making that whole definition in the earlier stage was because I wanted you to understand how that comes to the amendments to this act as well. Now, digital token, on the other hand, is a digital representation which is recorded on a distributed digital ledger, whether cryptographically secured or otherwise. So that is what they added in section 2 of the CMSA. And then what happened was they then added in section 3 to allow the security commissions to enforce their powers in handling digital assets. So they then basically in section 3 they explain first what is to be a security. How does digital currency and digital token fall under the definition of securities? And when this happens, then the security commissions will have that responsibility to regulate these securities because that is their duty, their role. So a very long story short of this whole section is basically digital currency will be considered a security when it's traded in a place or facility where offers to buy, sell, or exchange made or accepted regularly. Now, an owner of the digital currency expects a return on its value, and it's not issued or guaranteed by any government body or the central bank like Bank Negara. So that is when digital currency is deemed to be a security when they do not, when they fall under all this three definition I just provided you with. So then when a digital token would be considered a security, it's a little bit more complicated to a digital currency because it is usually used as an alternative to company shares. So sometimes it may be even used to bypass many statutory requirements, such as providing a prospectus for investors. So the new law here declares digital tokens to be securities if they satisfy the following requirements. There are about 6 here. So 1, an owner receives the digital token in exchange for a valuable consideration. 2, the consideration or contributions from each owner of the digital token and the income or returns are pooled. 3, the income or returns of the digital token are generated from business activities. 4, the owner expects a return on the value of the digital token. 5, the owner doesn't have day-to-day control over the management of the business involved. And 6, the digital token is not issued or guaranteed by any government body or central bank, again, like Bank Negara Malaysia. Now, moving on. This section 4, is basically what they do is securities law shall apply to all digital currency and digital token that have been prescribed as securities under section 3. That's why I was trying to define how section 3 comes into place just now, and how with that the securities commissions will have the power to then regulate these digital assets that is considered to be securities. Now, they then went on to explain that this is true except for Division 3 of Part 6 of the Act, which is the Capital Market Service Act, in which contains provisions pertaining to the conduct of business. Now, I don't want to go into depth here for this because it's a bit lengthy. So, yeah, I'll just move on to the next amendment. So, okay, this section 5, it basically clarifies that digital token or digital currency are not allowed to be recognized as a share in or debenture of a body corporate or an unincorporated body. Now, so this one is basically, well, I think it's quite self-explanable. Sorry, self-explanatory. Sorry. Now, the next section, section 34, makes it that where a person has applied, the Securities Commission may register the person as a recognized market operator subject to terms and conditions at the commission where it considers to be necessary. Now, this is the one where it's very interesting because, I was going on about Luno and how they're being illegal and stuff. So this is where the law was amended to ensure that you would then become a recognized market operator. And when you are a recognized market operator, then the business that is being run by you will not become illegal as they have deemed to be found in the Luno decision. So I provided a link here. The website basically contains the listing of recognized market operators or the digital asset exchanges, which are not permitted to continue, as well as digital asset exchanges that are still in the transitional period. Now, when I talk about transitional period here, was when the amendment, when the prescription order came into place, Securities Commission made this thing called a transitional period for current exchanges that were deemed illegal, that were running things without any they were conducting digital currency exchange without being recognized at the time, because how there were no laws at the time. So they call this a transitional period. It's like when they made these amendments, it's to allow these unrecognized market operators to follow this Security Commission's newly drafted guidelines to allow them to become a recognized market operator. So that is what they mean by transitional period. Now, to date, there are only currently 3 recognized initial exchange offering platform operators, which are Luno Malaysia. That's right, folks. Luno has registered themselves, and now they are actually the recognized initial exchange offering. So it is possible with this in play. We're not exactly, I can't really say per se because there's not a lot of cases that deal with digital currency, but in Malaysia as to date. So we're not sure how, with them now being a recognized, would that mean courts will fully implement like restitution into their previous decision, that kind of questions. It's quite an interesting area, and we hope that eventually the courts will look into this with more cases on digital currencies coming in. And the second one is Synergy Technologies and Sdn Bhd, and the final one is Tokenist Technology and Sdn Bhd. Now moving on, the SE guidelines. So for one to be an initial exchange offering platform operator, one must follow the SE guidelines that have been provided. I'll just run through this very briefly. As I've referred to you, I put a source here. That's basically the website where it gives you the guidelines as to how you can be an initial exchange offering platform operator. So very briefly, an issuer must be 1, a Malaysian incorporated company, 2, have its main business operations carried out in Malaysia, and 3, only raise funds through IEO and not through any other means. Now, an issuer must also have a minimum paid up capital of 500,000 and shareholders' funds of 500,000 maintained at all times. Where an issuer is a limited liability partnership, the issuer must have a minimum capital of 500,000 maintained at all times. However, the Securities Commission may at any time impose any additional financial requirements on an issuer, depending on the nature, the operations, and the risk that is being posed by the same. So the issuer's board must at all times have at least 2 directors, like a company, whose principal or only place of residence is in Malaysia. An issuer must also ensure that its directors and senior management are fit and proper at all times. The issuer's directors and senior management must in aggregate own at least 50% equity holding an issuer on the date of the issuance of the digital tokens. Post-issuance of the digital tokens, issuance directors and senior management may only sell, transfer, or assign not more than 50% of their respective equity holding until completion of IEO project. So that's the few guidelines on this whole what you should be for the SC to consider to for you to become an initial exchange offering platform operator. Yep. So moving on to the next amendment, which is actually the enforcement of Section 58 that provides that when a person needs a capital markets service license to carry out such activities pertaining to digital currencies, the failure to do so would mean that there will be an offence that has been committed and shall, on conviction, be liable to a fine not exceeding 10 million ringgit or to imprisonment for a term not exceeding 10 years or both. Now, what do they mean by regulated activities here? That would include the dealing of securities such as digital tokens and currencies. And of course, there are so many more, but like I say, this presentation is only focused on digital currencies. So let's leave that as that. Now we go back to how anti-money laundering laws would be applicable to this, how it comes into play with digital currencies and the worries that has been involved in it. Because you know how I was earlier talking about how it's a transaction that can be borderless. It can involve many countries, and you don't know where these transactions are being, I mean, where it can come from. It can come from USA. You can be dealing with someone from Japan. I mean, yes, your ledger will show you where, but like again, it's anonymous and everything. So yeah, basically you don't actually know who you'll be dealing with. So there's this possibility that you may be sponsoring, you may be dealing with transactions that may be involved with some terrorism, or you may be, dealing with transactions where it's being used to finance unlawful activities. So that was why Bank Negara announced that this is quite a bit of a worry. So they then inserted in paragraph 25 of the first schedule of the Anti-Money Laundering Act, which is also known as AMLA, in where it mentions that there were actions that being taken to ensure that effective measures will be in place against this money laundering and terrorism financing risks through the use of digital currency. Moving on. So what then do they mean by paragraph 25 of the first schedule of the AMLA? So it is clear here that it consists of reporting institutions that were involved in the services in the exchange of digital currency. So here is basically stating that AMLA is applicable to the exchange of digital currency as well. Now, it is also clarified here that the digital currencies are different from electronic money as defined in the Financial Services Act. Now, so moving on, Inland Revenue Board has also considered the Income Tax Act, the 1967 one, is also applicable to cryptocurrency traders as well. This is now reflected in Section 3 of the Act, in where it provides that tax shall be charged upon the income of any person accruing in or derived from in Malaysia. However, pursuant to the enforcement of the Capital Markets and Services Prescription of Securities, Digital Currency and Digital Token Order 2019, it is currently uncertain as to how that amendment has shifted the regulation of digital assets as securities to become to this Income Tax Act 1967. I'm still looking to see if there's maybe more. But I think currently, based on my current research, I have not found any differences to how that would come into play and everything. All right, so I believe I've gone through quite a lengthy presentation. I will take some questions and answer maybe. I'm sorry if the regulations that I've went through, it's a bit broad, and I'm just touching base, because the main the main acts that are still in place is actually still the CMSA that is being applied to digital currencies as a whole. As to how AMLA and the tax one, it is quite clear that uh, for now, just be known that AMLA does apply, but how that applies, how that becomes a full picture kind of thing is yet to be decided, because like I say, currently there's not any cases dealing with digital currencies, and like I say, the first case was Luno. There may be more that's coming in, and there's more being decided as we are having as time passes. But until then, just know that these acts do apply. Yep. So, okay, questions and answers. Okay. Oh, unfortunately, our firm has yet to deal with any legal cases on cryptocurrency. But I have a question that's asking whether on do you think that you can just email to us and maybe we can have a further discussion on this? Do you yeah, sorry. Yeah, that's my email right there. ysm@thomasphilip.com.my. If you want to further discuss on some case files, please just email me there, because it's a bit hard for me to have a full understanding of what your legal issue is as of now. Yeah. Okay. I also just want to give a little special thanks to my paralegal, Jingyi, for helping me in this presentation while we're still waiting for more questions and answers. Yeah, so like I just mentioned, any inquiries, feel free to email me here. For crypto traders, when and how does the tax apply to them? And how much is taxable? Is it already commenced in Malaysia? Now, I'm not very completely familiar how, because I'm not familiar with tax law and how that would apply to crypto traders. But I understand that the like I said, that Inland Revenue Tax Act does apply. Section 3, the Income Tax Act, sorry. Income Tax Act does apply to traders. How it would be applied, that will be something you may have to find out through someone who specializes in tax. Yeah. It's definitely commenced in Malaysia already, though. It's definitely commenced. But with the recent amendment, like I was mentioning, the Capital Markets Prescription Order Act, we're not exactly sure now that it can be viewed as a security. How does the Inland Revenue Board make that taxable? So does every trade, maybe certain percentage, how much trade will come out to that kind of tax? What is your income? Do they only tax you upon your withdrawal of that asset? Do they tax you upon your exchange of that digital currency into money? So like basically when you're withdrawing your Bitcoin and then after that you convert it back into money, do they only tax you based on that? Or do they tax you based on how much you have been trading as a coin? Yeah, so those are questions I'm not entirely sure of, unfortunately. But if you wish, I could maybe have you email me directly and I can maybe do some further check on it if you want to. I'll be happy to do it. Yeah, no problems. Okay, any more questions? Well, while we're waiting for more questions, I'm just going to do a bit of advertising. As you all know that we have all these talks and webinars is going on. I believe we have it almost every day. So please do check out. We always advertise them on Facebook. We advertise them. If you want to, you can register with us in our newsletter. And you can just come to our website to see what we do. and what else, uh, what areas of law, what other areas of law that we do. Um, yeah, so it will be helpful that all of you just join us for these talks, and I know it's gonna be casual and things like that, but I hope it's at least enjoyable for all of you, and topics that, maybe we got some topics that you want us to probably talk about. Maybe just feel free to email us at our admins, and then we can see how we can arrange for something. Yeah. All right. So I don't think I've gotten any more questions and answers. Oh, okay. There's a long one from Jonathan Silva. The submission of a white paper by an IEO issuer under the guidelines on digital assets certifies the requirement in the CMSA for issuers of unlisted capital market products to seek authorization and register disclosure documents with the SC, or will issuers also need to seek authorization or register disclosure docs in addition to complying with the digital asset guidelines? Sorry, I'll have to reread that again. Mhm. Um, when you're referring to the digital asset guideline, can I just clarify? Do you mean the one that is released by the Securities Commission? Because at the end of the day, yeah, okay. So, okay, for this, honestly, most of the guidelines that you're referring to, it will have to be, you will have to follow whatever the security commissions have implemented. So if they're asking for maybe a white paper by an IE, when you're talking about a submission of a white paper, if it's pursuant to the guidelines, then yes, um, it will usually be deemed to be sufficient then. So as long as the whatever that's being issued, or whatever that issuers are required to do, everything is very clear cut in the guidelines. It's very one by one step. So if they're stating that there's this white paper to be issued by an IEO issuer, then yes, they will have to satisfy. But then you have to take note when you're reading through these guidelines, maybe there are some additional things that you have to consider. So maybe if you're stating that issuers also have to seek for authorization or register of the disclosure docs, then yes, you know, that that will all be in the guidelines. Yep, no problems. Glad to help. Any more questions? If not, I'll end this session for today. I hope you guys have enjoyed this. I really, really hope it's been at least helpful, because um, I was a bit afraid that it might be a bit lengthy on the law and stuff. So yeah. Okay, so thanks so much if you all enjoyed this session. All right. Any further questions and answers? Sorry, any further questions, clarifications, or any inquiries, please feel free to email me here. That's my email address. I will try my best to look into some of the inquiries that I've got just now. Yeah, feel free to email me those, and I will try to get back to you as soon as possible. Yeah, okay. I hope all of you stay safe. Please, with the MCO, the COVID, just stay at home as much as possible, and have a really good time. Please keep all your mental and your physical health well. And yeah, have a good day ahead of all of you. Thanks so much for joining this session. Thanks, everybody.